David, over to you again. Ineligible members.
Okay, it's been brought to my attention from various members over time that why don't we publish a list of those folks who are delinquent, not paying their bills? So I drafted a motion here and actually cleaned it up just a touch late today, thanks to Robin. The only thing that changes is on the specific motion, the first 10 or so words before the word resolution. It's been smoothed out a little bit, makes better English. So it now reads, the names of members of LHCC Inc. who are not in good standing according to the terms of resolution and so forth. So, you've all had a chance to look at this hopefully, and some folks don't think we should do this. We've been advised by some legal folks not to do this. I think we should do it. I feel like if we stick to resolution 2008-02, we have adequate safeguards not to make a mistake, because there are late charges, there are reminder notices, there's a final notice, and then there's even a board hearing before somebody is declared not to be a member in good standing, if we follow that resolution. It's very well structured. So, I don't know, I think we ought to do it. Vote for debate.
Well, you know I'm in favor of it, because I've expressed that before, and it seems like you've taken a very careful approach to it, and my opinion of lawyers' opinions isn't real high, so I think we ought to do it.
Yeah.
I think we should too. We've talked in this meeting before. I've been at places that have done this, and granted they've been towns, not POAs. I feel we need to do something. I think again, it's as protected as it can be, as long as we follow that resolution. I would lead up to this for at least 2 articles and 2 consecutive newsletters that we are going to do it.
I think that's an excellent idea.
Get people ready, so that when it happens, they can't say you never told me it was going to happen.
Right.
But I think we've got to do something. There's nothing else that we're doing that's helping this cause. I don't know if this will, but I think we should do something.
Joanne?
I agree. I think that this will provide enough safeguards, and I think the point was made by several attendees at the May meeting that something like this is necessary. People were very disturbed that there's the level of delinquencies that we have, and I think it's something that the membership wants.
Right.
This is part of your collection process, and your attorney representing you in the Beams case has advised you not to pursue collection efforts against those sections in a Beams case. And I see that all part of the same. And in doing that, you're going against his recommendation. The reason for his recommendation, and if any of this appears in the lower court, it may very well compromise your position in the Beams case.
Joanne?
I think I disagree with that. I mean, our position in the Bemis case is that we are legally collecting dues from members. And, I don't see how, publishing that people are delinquent in their dues is going to impact the judge's decision in the Bemis case. He's either going to decide that, we have a legal basis for collecting dues, or we don't have a legal basis. And certainly as to a lot of these sections, it's pretty clear, a lot of the sections where we have high delinquencies in some of the membership lots, the deeds are pretty clear on what our authorities are.
That's such a tiny fraction of the collection. Like you have 29 delinquent accounts in sections outside of the Bemis case.
That's not what Joanne said. She said many of the membership sections, the deeds are clear about our abilities to assess, including all of the Bemis sections except 1 and 2.
Including our ability to place liens I mean, it's in the deed.
But we're not pursuing any collection efforts against any of the sections named. So this is, why don't you consider this part of your collection agency?
This isn't we're not going out to collect
Well, you're
anything
saying
by
our past-
publishing this. We're just saying that, stating a fact. The following individuals are delinquent in their dues.
Right.
To the extent that there's collection, there will be peer pressure. It'll be, I don't see this as a collection effort.
Okay, John?
Yeah, I too want to speak in favor of this approach. I too have had a number of members come to me and say, why don't you do this? I have spoken to my personal attorney. He said there is no legal reason to not do it. You need to make an assessment of the risks and then proceed accordingly. And thirdly, our accounts receivable are absolutely out of control. $750,000 are owed, and we've got to avail ourselves of any and all opportunities to start whittling away at those numbers. So I'm totally in support of this, and I think we ought to do it without any further delay.
Yeah, I think to go a little bit further, yes, our attorneys advised us with the Venus case not to do this. However, to go after delinquencies. However, I think when that happened, perhaps we were thinking very positively that the Venus case was going to be settled long before it will be, whenever that is.
In our lifetimes.
And we thought, yes, that will get us into the first of this year, maybe, and then we'll be able to attack it. Well, we're now halfway through the year, and it'll be August, maybe later. One way or the other, we've got to start getting our money. And people, whether they suit us or not, do not have the right not to pay their bills until that judgment is made. So I'm not sure that our legal advice that we got was correct, but we've done that and we followed it, and I think we should continue, but I think we should go forward with this.
Okay. Ken?
Such a list gives us an opportunity to know, on a named basis, who's eligible to use the amenities and who isn't. Because right now, unless you happen to know that your neighbor isn't paying his bills, you don't have a clue whether he's eligible to use the beach.
Good point. Okay.
Well, I so move what's in front of you with the addition that, actually, since it's too late to get in the June newsletter, how about we put it in the July newsletter that it's going to take effect, one month after that.
I thought you were going to put it in 2 newsletters.
Give everybody a full month to,
And it can go on the web.
they could go on the web.
Now, so the
Yeah.
web now, and then the July newsletter, and that's adequate notice.
Well, why delay? Why not put a letter out to every individual delinquent account advising them of this? You have to do that anyway.
How many
You should do
letters?
it anyways. Wayne suggested it. What, I'm sorry?
It's a good idea. How many letters are we talking?
I don't know what
No,
you're
I don't want to throw.
738.
No, I don't want to send out 700 letters. No.
Yeah.
We've already wasted too much money on these people. Let them read the website, let them read the newsletter, and let them react
Well,
accordingly.
none of them not live here. I mean,
No,
we send a newsletter.
they get the newsletter, they have access, they have internet, most of them.
Everybody's always got an excuse why they don't know.
What, I don't think we need to coddle these people anymore, frankly.
Can we be sure, John, if we don't do one last cycle, confirmation that our records are?
Oh, I'm not saying we don't look at the records. We look very, very closely and carefully at our records. But that's independent of what we're doing here
I
tonight.
think you owe each individual an opportunity to respond. And I think that gets you off the hook with it and helps mitigate your exposure to it at the same time.